be set higher than $1,000 because to set it back to where it was when he was first arrested would be essentially turning a blind eye to the fact that he's now before the court, allegedly where the court's found probable cause, committing a violent act against a law enforcement officer. And as far as the pending case.
Yes, Joshua Vince for the state. And as far as the pending case goes, Your Honor, he did cause injuries to the officer. The officer was required to seek immediate medical attention after the incident with the defendant, and the defendant did flee from the scene after causing injuries to the officer. So,
okay, so Mr. Sirota, what the court is going to do, I am going to revoke your pretrial services that you were placed on in order that you have a $1,000 bond on the original case, which is 17-002584-MM10A. 1,000. And on the current case, the court is setting bond on count 2 in the amount of $5,000, and on count 3 in the amount of $2,500. The court is ordering no contact with the alleged victim. Good luck.
Yes.
Daniel Lee Mace. Mr. Mace, you are here on a felony retail theft charge. The court does find probable cause, and you have bond set in the amount of $1,000.
Thank you very much, Judge.
You're welcome. Dominic Brian Santafemia.
Mr. How do you pronounce your last name, sir? Santafemia. Oh, okay.
Okay, Mr. Santafemia, you are here on 2 violation of community control warrants and 2 felony capias warrants. There's currently no bond hold, but you are going to court on May 30th. Good luck. Yes. Tercel Reckley. Mr. Reckley, you're here on a grand theft auto. The court does find probable cause. You have bond set in the amount of $1,000. Francesco Mera.
Mr. Mayor, here, Judge, you informed us you have private counsel.
Okay, thank you. Mr. Mera, you're here on a violation of probation warrant. There's no bond hold, but you are going to court on May 30th. Good luck. Christian Delgado.
Mr. Delgado, come on up, please. Good afternoon, Your Honor.
Hello, Mr. Delgado. Now, you're here on a suspended license misdemeanor. You also have a probation violation and an out-of-county hold in a civil matter. The court does find probable cause. On the current offense, it's a $100 bond, but there's a no bond hold on your probation violation. And there's, on the civil out-of-county hold, the amount is $6,326. Will be brought to court to address your violation of probation.
Judge, one request from the defense. I understand, Mr. Delgado, I know the probation hold is out of date, so until the matter of the driving is taken care of, he won't be transported back to date. The purge amount on the child support is $6,328. I'd ask you at this time to consider an ROR on count 1 so that Dade County can pick him up, he can address his probation case, and then all the money that he had that would have gone towards the bond or the cash bond on count 1 could go towards the child support. And I'm making that request, Judge.
Okay, I'll tell you what. If he wants to resolve his suspended license charge, the court will offer him a withhold and court costs. He doesn't have any priors in the last 5 years. This would be strike number 1.
The only reason I'd be reluctant to is because he's on probation. This would be a basis of violation.
Okay.
I appreciate that, Judge, but that's why we're requesting an ROR.
The court will ROR him on count 1.
Thank you, Judge.
You're welcome. Raymond Anthony Serrano.
Mr. Serrano?
Mr. Serrano, you're here on a capias on a possession of cannabis charge. You have a number of traffic tickets, and then you have a violation of probation. There's a $500 capias on the cannabis charge. There's a no bond hold on your violation of probation, but you're going to court on May 30th to address it. Good luck.
Good luck.
Daniel Lushinsky. Hello, Mr. Lushinsky. You are here on possession of THC and possession of cannabis. The court does find probable cause. You have a $1,000 bond.
Judge, I'm speaking with Mr. Lashinsky. If the state can verify, he's advising me this is his first arrest ever. He's a registered voter. He's currently employed. He works for a company called U.S. Information Computers. He's a computer technician, been working there for about a year and a half. At this time, Judge, financially, he tells me he's going through some hard times. Considering this is a cannabis charge, nonviolent offense, if it's his first charge ever, would you consider an ROR on his behalf?
State, what's your position? Does he have any priors?
No, Your Honor. We have no objection.
Okay, your request is granted.
Thank you, Judge.
You're welcome. Mohammed Aslam.
Mr. Aslam is here present, Judge. We'd be waiving formal reading of the charge.
Okay. Mr. Aslam, you are here on, and I'm sorry, waiving a formal reading. Does it mean I can't say what the charge is?
Yes, ma'am, if you don't mind.
You can, but they're requesting you now.
Okay. All right, Mr. Aslam, I've reviewed your probable cause affidavit. The court does find probable cause. Does the state wish to be heard on a bond amount?
Yes, Your Honor. The state's asking for a $50,000 bond, no victim contact, no minor contact, and if he does bond out, a GPS monitor.
Contact with minors.
Yes,
Okay.
no contact with minors.
Okay, and does the public defender wish to be heard?
Judge, in reference to Mr. Aslam, he's been residing in South Florida for 4 years now. He's 31 years old. He's currently employed. He works at a gas station. He's been working there for 2 years. He is a cashier. He makes approximately $10 an hour. My understanding is this is his first arrest ever. He lives in Coral Springs. He lives with his mother. He's been residing at that apartment now for about 2 years. Their monthly rent is about $1,345, which they do share the expenses. My understanding is the only person that's going to financially be able to post his bond would be his mother. I'd ask you to set a reasonable bond as to Mr. Aslam, take into account his financial resources and his lack of criminal. Regarding the pretrial, we have no objection as far as pretrial and no contact. However, 2 issues. I believe there's going to be I believe on the pretrial order, there's going to be, with the no contact order, there's going to be a 500-foot requirement. My understanding is the alleged victim are neighbors. My understanding, Judge, is that I guess he lives on the first floor. The alleged victim is on the second floor. So I don't know if it's going to be within the 500 feet. I'd be asking you at this time to consider a no harmful contact, and I do understand the court's concern, so I don't know if Your Honor will go ahead and entertain that request.
Okay. At this point in time, Mr. Aslam, due to the nature of the accusations that are contained in the complaint affidavit, the court is going to issue a $50,000 bond. I am going to order that if you do bond out, you are going to have a ankle monitor through a GPS monitor through pretrial release, and I am concerned about the no contact with minors because I don't know how enforceable that's going to be with any minor.
Well, Your Honor, and it wouldn't. My understanding is it wouldn't involve like incidental, contact. For instance, if he goes to a store and a minor happens to walk in, it would be direct, intentional contact with any minor, Your Honor, and it would be. I'm sorry. And it would be enforced that if, just a hypothetical situation, if he were to be pulled over and there happened to be a minor in the car with him, for instance.
Okay, I understand. Let me hear from the public defender.
Judge, I'd be objecting as far as no contact with the minor. I wouldn't object to no contact with the alleged victim, of course. I understand that rationale, but as I said, he is a cashier. If there's a patron that walks in with their child, or if for that matter, a 17-year-old walks in and buys a Coke, I mean, it just seems vague and overbroad. I understand as far as no contact with that specific alleged victim. There's no history, there's no pattern here as far as no prior offenses, and that's why we'd be objecting as far as that overbroad blanket order.
Your Honor, and that's why we're requesting direct intentional, and if counsel's concern is his employment, then we'd have no objection to the order not involving anything that is work-related.
Okay. The court's going to enter an order, no direct contact with minors, with the exclusion of work-related business.
And as far as the one issue I addressed earlier, as far as the foot requirement, because I believe first floor, second floor, I don't know if you're gonna.
Okay, well, the court is ordering no contact with the alleged victim. If there is a 500-foot requirement, he can't be within 500 feet of her. That's the bottom line.
Yes, Judge.
Okay.
I
Derek?
just need to explain something to him.
Okay.
The ramifications of that.
Okay.
Remember, you got to put all the conditions.
All right, Derek Paul Francois.
Mr. Francois, come on up, please.
Mr. Francois, you are here on a grand theft charge and passing a forged instrument. The court does find probable cause. You have bond set at $2,000.
Mr. Francois is asking me to request Your Honor to consider pre-trial release. He's been residing in South Florida for 29 years, his whole life. He lives in North Lauderdale. He lives with his sister. Their net rent is about $1,000. He is currently employed. He works for a staffing agency, making about $10 an hour. Judge, Mr. Francois, as you're going to find out from the state, does have a record. He has gone to prison from what he's advising, but he got out in 2013. And if the state can verify, he's had no felony arrests since 2013. He's changed his life around. The only person that could potentially post his bond is his sister, but he informed me that his sister right now is pregnant, 8 months pregnant, 8 months pregnant due. So right now, she's not in a financial position to go ahead and post his bond, and that's why he's requesting you to consider the
State, does he have any prior since he was released from prison?
In 2010, he's got a resisting without violence and a petty theft, which is second offense. In 2010, he had a resisting without violence, was an adjudication, and a petty theft adjudication as well.
That's the concern.
In 2015, he had a loitering and prowling.
That's the concern, considering what
Yes, and he was adjudicated on that, and that would be the concern, considering what he went to prison on in 2006.
Okay. Mr. Francois did pick up a criminal charge after he was released from prison, and this is the second time. The court is not going to refer him to pretrial. I'm leaving it at $2,000.
Yes, sir. The only last thing I'd ask you is sign a phone order.
Yes, your request is granted.
Thank you, Judge.
Travis Delancey Pittman.
Good morning, Judge.
Hello, Mr. Pittman. Pittman, you're here on a burglary of an occupied conveyance and grand theft charge. The court does find probable cause. I am setting bond on count one in the amount of $5,000, and there's a $1,000 bond on the grand theft. The court's ordering no contact with the alleged victim, Zandranice Camille Lamoth.
I'd be asking you to consider reducing that. He's been residing in South Florida his whole life. He's 27 years old. Right now he is employed. He works for a transport auto company. He's been doing that for about a year. He makes about $300 weekly. He's also going to school at Sheridan Tech. He entered actually he's not going to school. He just applied. He entered, he got accepted into the electrical program. He's scheduled to start June 12th. He lives in Hollywood. He lives with his parents. He's been residing at the same apartment for 10 years now. My understanding is, speaking Mr. Pittman, his last offense was about 3 years ago for cannabis. Judge, that's why we'd be asking you to consider a $1,500 bond on count one, and the $1,000 bond would be a total of $2,500 bond on Mr. Pittman's behalf.
State, what kind of priors does he have?
2013, violations, and this one, Your Honor. And the only concern we have here is the fact that the daughter that he has in common with the victim was present for this, for the burglary and the grand theft that happened inside the car.
I do understand the state's concern. Mr. Pittman, the court is going to grant your attorney's request. I'm reducing the bond amount to $2,500, and you're to have no harmful contact with your daughter and no contact with Zandranice Camille Lamoth.
If it's possible, I have to pick my child up from school.
No harmful contact.
No,
You're-
I mean as far as the mother picks her up from me. So is it possible that I can call the proper law enforcement in order to engage a smoother transfer?
That's a good idea. What he's basically saying is, Judge, I believe the mom and him have some sort of arrangement where she drops them off, he picks them up for the sake of the child. What I would request, Judge, is they can agree on through a third party for purposes of arranging for child visitation, custody, and transport, if that could be allowed.
That's exactly what I was going to suggest. You have a third person arrange the pickup.
Thank you, Judge.
Okay. Victor Mott.
Mr. Mott?
Mr. Mott, you're here on a violation of probation. There's a no bond hold. I'm sorry, no, that's incorrect. I misspoke. The $250 bond. I apologize about that. There is a court date on May 30th, if you're not able to post bond.
I got a quick question, ma'am. This probation, and I have a bond for probation violation. I've never had a bond for probation, but I don't know how it works. If I bond out today, what do I have to do?
Then you get out of jail and you go to court on May 30th.
And that's it. Don't report to the probation officer.
No, I would say yes. You still do. You're still on probation.
I just want to get it. I just want to get the terms and conditions right.
As a friend of the court, it's probably in his best interest, if he bonds out, to contact his probation officer upon his release, and his probation officer will direct him how to proceed.
Okay.
Yeah, I think that's a good idea.
Contact your probation officer if you do bond out. You do have a court date on May 30th, but let your probation officer know that you did bond out.
Thank you.
Okay.
God bless.
Judah Gill?
Mr. Gill?
Okay, Mr. Gill, you're here on a trespass charge and probation violation. I do find probable cause. There's a no bond hold on the probation violation, but you're going to court on June 5th.
June 5th?
Yes, that's the first date. Good luck.
Why is this going on?
William Moore.
Well, he might be at another jail. What was the bond originally?
Mr. Moore, I think according to the docket, it says medical loan.
Medical?
It's a medical reset.
Okay, we'll reset him. Jerry Wells. Mr. Wells, you're here on a trespass charge, and you have 2 violation of probation warrants. There's a $25 bond on the trespass. The court does find probable cause. You're going to court on May 30th on your violation of probation. Good luck. You're welcome. And Jim Alvarez.
Currency, Your Honor.
Okay, thank you. All right, I need the arrest affidavit.
Your Honor, this is a change of charge also.
Okay, so Mr. Alvarez, you're here on a change of charge on, the charges have been changed to burglary of an unoccupied dwelling. State, what was his original bond?
Your Honor, the original bond was $10,000. That's going to remain at $10,000.
He's being held on a VOP for dwelling, no bond.
He's being held on a VOP for burg dwelling, no bond.
Okay, so Mr. Alvarez, I'm going to leave bond set in the same amount, $10,000 on each charge, but I was advised that you're being held no bond on a violation of probation.
Yes.
Okay, good luck. All right. Thank you very